If you live in Florida, you know that Floridians pay some of the highest car insurance premiums and homeowners insurance premiums in the country. Many have looked to the state legislature to find a way to drive those costs down. Some lawmakers say they found a way to do that indirectly in a new bill, HB 837. The bill makes it harder for policyholders to sue their insurance companies. Let's bring in Edward Reyes from the Reyes Law Firm in Tampa to talk about this. Edward, thanks for joining us. So, for years, the legislature has made it harder to sue property insurance companies. My understanding is this makes it harder to also sue your car insurance company, your life insurance company, your health insurance company. Is that right?
That's correct. In fact, when it comes to certain insurance companies, it goes back to the first party, the property insurance company, and how you cannot make a claim anymore against your own property, which is a major problem for our Florida citizens.
What are the other ways that this bill would make it harder to sue the insurance companies?
Well, one of the big topics is called bad faith. Basically, the insurance company has a duty to defend and indemnify you in case of a lawsuit. For example, whenever somebody makes a demand for settlement against the insurance company for injuries that their client may have caused, that insurance company needs to comply with that demand or value the demand correctly to not put that client in risk of litigation, their own client, that is. So what happens out if they eliminate bad faith, the insurance company can basically do whatever they decide, whatever they want to do, and not pay a claim or pay the claim at the basic level, leaving that client, their own insured, at risk of litigation and at risk of owing a lot of money to the plaintiff's lawyer for the injuries that was caused.
You were telling me before the interview started that this is sending shockwaves through the legal community. Why?
Well, because we can't really represent clients in the most efficient way as possible, because not only is the bad faith thing a major concern, because the insurance company, like I mentioned, they only have to pay, they pay the policy, but they don't have to comply with none of the other terms of the demand. So if we get a judgment of, $100,000 for whatever, on a case, if the insurance company complied correctly with the demand, their own client wouldn't have that issue. They wouldn't have that judgment against them. It would the insurance company would have to make them whole, and then so that's one thing for consumers. The downside to this is that if there's a client that's injured and it's a big injury, and the insurance company decides not to comply with the demand, that means that you can go to litigation, you can get this massive judgment against a defendant, and yet that judgment will never be paid to the injured party. So therefore, the client himself would never recover money for the losses that were taken from them because of a car accident or an accident in general.
Understood. Now, the argument for this bill is it stops frivolous lawsuits, which is a cost for the insurance companies, which is a cost that is often passed on to regular citizens. Do you think something should be done to stop frivolous lawsuits, and is this it?
I don't think this is it. I think that there should be a modification of what this is. At the end of the day, yes, there's people that bring frivolous lawsuits, and as an attorney, as a professional, if we hear somebody coming in, they're not injured, they don't have the issues, we try not to bring those cases. In fact, we discourage clients, listen, maybe call the insurance company, maybe see if you can work something out. If the injuries aren't substantial, if the injuries aren't there, we, as us, the Reyes Firm, we do not sign those type of clients up. That's a professional thing, I think, more than anything else. But as far as the lawsuits and raising the cost of insurance, because that's always a big issue for everybody, of course, as it is now, the insurance company's main objective is to adjust claims down. Typically, it's the natural order of things. We make, they collect premiums, and then whenever a claim comes in, they adjust the claims down. That can still happen. That can continue to still happen with the way it's been going, not having to go through all this tort reform that can leave people not being able to get representation. But with this new billing format, one of the tort reforms that they're trying to include is Lone Star billing. What this is about is that we have to become basically a billing machine. Right? That's what they're pushing us or asking us to do with this Lone Star billing. And that's going to cut into the client's recovery. So if the policy is a $10,000 policy, we can't work on, well, many attorneys will not be able to work on these cases for long periods of time, because now the client will end up getting zero recovery, because it'll all go into attorney fees, depending if the insurance company is looking to fight that claim, fire liability, or whatever the case is. What the things that they normally do with this new billing structure, many of the cases that are smaller policy cases, we are not going to be able to basically fight, or it's going to greatly reduce the clients that you help, because if not, that client could end up owing more money for their lawyers than they will on the recovery from the insurance policy because of their injuries.
Edward, thank you very much for your time. That is Edward Reyes from the Reyes Group in Tampa.